6 o'clock, so we'll get started. I'm calling to order a code enforcement hearing of the City of Cape Canaveral. Today's date is September 26, 2023. My name is Richard Geller, and I am Special Magistrate appointed by the City Council to hear code enforcement cases pursuant to Article 6 of the City Code, as well as Florida Statutes, Chapter 162. We have on the agenda this evening two quasi-judicial proceedings. The second one is known as a Massey hearing to impose fines. The burden of proof in both cases is upon the city to show by a preponderance of the evidence that a code violation occurred, or in the case of the Massey proceeding, continues to exist past the date established for compliance by a prior order. In other words, I will determine, based on the evidence presented to me this evening, whether it is more likely than not that a violation has occurred, or in the case of the Massey proceeding, continues to occur. The alleged violator will have an opportunity to submit any rebuttal or exculpatory evidence, including testimony, and in my discretion, I may allow a member of the public with relevant personal knowledge to testify, even if not called by either the city or the responding party. Anyone who would like to testify should sign the sign-in sheet where I'm indicating, and I understand we have one witness who will be appearing by telephone this evening, and we will provide for her to give such testimony. Upon request, an alleged violator may ask relevant material questions of any city witness, and the city, in turn, may ask relevant material questions of any witness for the responding party. I may exclude evidence that I deem to be irrelevant, immaterial, or unduly repetitious. In determining the amount of any fine, I will consider the gravity of the violation, any efforts taken by the violator to correct the violation, as well as any history of previous violations by the violator. Under the City Code and the Florida Statutes, I may assess and order the payment of a fine of up to $250 per day per violation for a first violation, and up to $500 per day per violation for a repeat violation, or, although this is rare in the case of an irreversible violation, a fine of up to $5,000, as well as the cost of any repairs made by the city. At the conclusion of the hearings, I will issue findings of fact and conclusions of law based on the evidence of the record, as well as an order, both here on the bench, and then I'll endeavor to do so in writing. Tomorrow is going to be tough for me, but by the end of the week, I would expect to have something to Secretary Roth. The city will record a certified copy of any order that imposes a fine, which will become a lien against the land where the violation occurs, as well as upon any other real or personal property owned by the violator. Any order I issue may be appealed by any party to the Circuit Court for Brevard County within 30 days, and it is the responsibility of the appealing party to obtain a record of these proceedings. An appeal is limited to the record that is presented before me today. And let me just note, as an administrative matter, the city's agenda packet will be administratively accepted as City's Exhibit 1, and its PowerPoint slides will be Exhibit 2. I have signed and approved the meeting minutes for the Special Magistrate's hearing that took place on August 22nd, 2023, and the next hearing date is October 24th, 2023, also here in Council Chambers. At this point, I will ask if there's anyone here who expects to testify as to facts, if you would stand and be sworn in. Do each of you swear? The attorneys don't have to if there's going to be making argument. Okay. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you. All right. The first case is case number 22-308 concerning 404 Tyler Avenue, Unit 6. And forgive me if I'm mispronouncing the name, Ludmila Chistyakova. And city ready to proceed?
Yes.
All right. Officer Costa, if you just introduce yourself for the record, please.
Code Enforcement Officer Kevin Costa.
All right.
Case number 22-308, Stiakova Ludmila. Address is 404 Tyler Ave, Unit 6, Cape Canaveral. Legal is Avon by the Sea, parcel 24-37-23-CG-39-10.06. The violation is for property maintenance, section 70-69, receipt required, section 504-1 and 504.3 of the International Property Maintenance Code and section 704 of the Florida Building Code. Revised notice of violation was sent out on 7/28/23. Return receipt of 8/21/23 to Ludmila Tiskova. On 8/2/2023, the property was posted in accordance with Florida Statute 162.12.
And at City Hall as well.
Yes.
Thank you.
The notice of hearing was sent out on 9/6/2023 via certified mail. Return receipt requested to Ludmila Tiskova, property owner. On 9/7, the property was posted in accordance with Florida Statute 162.12. On 9/23/2023, unclaimed was returned to sender.
Just hold the slide for 1 moment.
Sure.
I got it. You can proceed.
This is the aerial shot of the property in question.
The whereabouts is the unit that is at issue?
What was that, sorry?
I was just asking where the unit is that is the subject of this.
It's the lower left-hand corner of the property.
Okay.
It would be the second floor.
The second one, I'm sorry?
It would be the second floor of
Second.
the lower left-hand corner
Okay.
of that building.
I got it.
On 12/8/2022, the original notice of violation was sent to the property owner. On 7/17/2023, a complaint was received about a leak from Unit 6 into Unit 1. On 7/25, the inspection visible from the Unit 1 revealed that the plumbing did not meet plumbing code. On 7/28, the revised notice of violation was sent to the property owner. On 8/2/2023, the notice of violation was.
Can I just inquire there? So I suppose you were in Unit 1 and you were able to, was the ceiling opened or how?
It was open.
Okay, so the ceiling was open and you were able to inspect then the pipes that were between the two floors?
Correct.
Okay, including this shower drain that is at issue?
Yes.
Okay, thank you. All right.
On 8/2/2023, notice of violation was posted in accordance with Florida Statute 162.12. On 8/9, I observed that the notice of violation had been removed from the door and a courtesy call was made to the property owner. A voicemail was left. On 8/15, staff was asked to meet with the owner of Unit 1 to observe the water leak coming from Unit 6. On 8/24, notice of violation was returned to the sender.
So I assume that, and did you in fact go to Unit 1 on 8/15 and observe the leak continuing?
That's correct.
Okay, thank you.
On 9/6, the notice of violation or notice of hearing was sent to the property owner. And on 9/7, the notice of hearing was posted in accordance with 162.12.
Okay.
On 9/12, I observed that the notice of hearing had been removed from the door. As of today, a search of the BSNA database revealed that no permit or business tax receipt has been applied for.
All right, so when did you determine that a business tax receipt should have been applied for?
When the original notice of violation was sent on 12/8, the property was observed by staff to be posted on a vacation rental website.
Okay. Do you know what rental site you observed that on?
Airbnb.
Airbnb, okay.
We were also noticed at the time from Pro Champs that they had spotted the property as well.
And we're just, our concern is Unit 6, is that right?
Correct.
Okay. All right. What are we looking at?
This is the shower drain from the shower coming from Unit 6 that was observed in Unit 1.
And is there any visible leaking going on here?
Not at this time, not from this spot.
Okay.
But this drain pipe is what brings the drainage not into compliance with the city, with building code,
Okay.
because there is a smaller pipe than what it should be.
So so you have, I guess, your U-bend, and then there's a pipe going off there. Is it your contention that pipe should be larger?
It should be larger, yes. It should not go down in size. There is a clear picture.
Okay. And so is looks like a connection that is narrower. Is that what the issue is?
That's correct.
All right. Did you observe water damage in the ceiling before it was opened?
I did not know.
Okay, but that was reported to you by the unit owner of Unit 1?
Correct.
Okay.
This is what was observed by myself on 8/15 of the water leaking.
Okay, and is the leaking water observable in the photo, or is it hard to tell?
It's observed in the photo.
Can you point me where you see moisture?
Would you like me to come up there?
Well, before you do that, can you describe it? I mean, I'm looking at the pipe, I'm looking at the bend.
Just to the right of the bend
Okay,
of that elbow, you can see that there's a water drips.
are they on the pipe itself? I'm gonna let you come up and point it out to me. See? Okay. All right. Thank you very much. So may the record reflect that Officer Costa identified two water drops that have accumulated in the ceiling that are approximately, I'm going to guess, 6 inches to the right of the bend of the pipe. Is that a fair description?
Yes.
Okay. And now that you pointed out to me, it's very apparent. Okay. Is this, and just going back, what is that ceiling made out of? It looks like some sort of cementous,
I'm not sure what that ceiling might be made out of.
it looks like stones or something that's part of the,
It may be concrete. I'm not.
okay,
It would be concrete.
thank you. All right.
This is a photo of the property being listed on a rental website.
That's on Airbnb?
Correct.
Okay. And we've had a number of issues with these. One is some property owners do not register them to begin with ProChamps, and that appears to be the case here. And the other issue is that the duration is too short for what's required under our code. Is that also an issue here? Or have we not looked at that?
What was that? Sorry.
So is the duration of the rentals, there's a minimum duration of the rentals that from what I recall, that our city code requires. Is that an issue here at all?
I don't have that information
Okay.
with me right now.
All right, well then.
I can get it for you if you'd
Well,
like.
well, no, if the respondent has not been advised of that being an issue, then we will not proceed on that. So we'll proceed this evening on the fact that the property has not been registered with pro-champs, which is the city's contention, correct?
No, the business tax receipt.
Okay. So the unit is registered with pro-champs?
We're no longer working with ProChamps.
Oh, we're
at
not?
this time.
Okay, so are registrations done directly with the city?
Can I, I'm
Please.
sorry, can I answer that real
Have
quick?
we changed our code?
Yeah, no, we actually, ProChamps went out of business. They
Okay.
filed for bankruptcy a couple months ago. The city's in the process of getting a new company.
Okay.
And as of right now, since we're without anything, we've actually put a hold on all of the registrations until we can we've actually accepted Deckard to come online with us on that, along with our foreclosure registry. And hopefully in the next few weeks, we'll be online with them.
Okay, so this evening, we are not pursuing the city is not pursuing any contention that this is an unregistered property. All I have before me is the fact that a business tax receipt has not been obtained by
Yes,
the
sir.
property owner. Okay, I got it now.
It would be the business tax receipt as well as the Florida building code because
Right. Yeah, I was just focusing on the rental aspect. I think all right. Okay.
another photo of the property being listed on vacation rent.
Okay. All right. Is there anyone here representing the property owner who would like to address me? Okay. But before I hear from you, is there anyone though from the Unit 6? We're all with Stark. You're all with Stark. I got it. Okay. So then the property representative, there is no representative for the property owner. In that case, I'll let you come up and address me. If you could please state your name and address for the record.
Okay, my name is James Cardarelli.
How do you spell the last name?
C-A-R-D-A-R-E-L-L-I.
All right.
My wife Diane and I are property owners of unit number 1 at 404 Tyler.
Okay.
We reside at 3419 Sea Grape Drive in Winter Park, Florida. 32792.
All right.
All right.
right.
So this is the second time we've had an issue with Ludmilla regarding the leak in the bathroom. About maybe I'd estimate 5 years ago. Similar problem, leaking into the drywall above our tub.
Yeah.
And they were real quick. She and her boyfriend Ryan, who I believe is the handyman who did the job, the fixing up job in the first case. I think they took out a bathtub, put in a walk-in shower,
Okay.
which is up there now. So on June 25th, our daughter was at the condo there and noticed stains on the ceiling in the above the bathtub.
Okay. What's your daughter's name?
Kerry, Kerry,
Okay.
Hayes, Hayes.
Okay.
So she sent us a couple of pictures. I don't have a thing like that I could show you in a.
Your testimony is good enough.
Okay. So that was June 25th. Deborah Carroll, who is the manager of the condo association,
And that's Carol, C-A-R.
Carroll.
Okay.
Deborah,
Got it.
contacted Tom Walker Plumbing. They came over and inspected. At that point, she cut away a little piece of the drywall, which was about to fall down. Saw the leak that was described with the drips coming off the concrete. And eventually took away all of the drywall above our bathtub because it was all soaked.
Is this the plumbing contractor that removed the ceiling to get
Yep.
to get to it? Okay.
Tom Walker removed the drywall.
The drywall and this concrete.
The concrete and the pipes are now visible because all the drywall has been removed.
Okay, got it.
That's been 3 months now.
Okay. So you've been living with this with a hole in your ceiling for 3
Correct.
months.
And currently,
All right.
the leak is worse than it was in the pictures. And the wood below the leak is been getting dripped on. We did some fairly extensive mold cleaning after the drywall was taken down. Went to Ace Hardware and got some products and cleaned up everything real good. Ludmilla has not returned any of our calls, has not answered any of our calls. And so it's been a frustration. Now, the first day that Tom Walker Plumbing was there,
Let me stop you. So she's not returning calls. Have you tried contacting her in any other way, by text message or email or any other?
I don't know about email, but texting
Okay.
and phone voicemails, yes.
Okay.
On the first day that Tom Walker Plumbing was there, Ludmilla and her boyfriend Ryan happened to be there and came and inspected things as well.
Okay.
And she was very quick to blame, oh, it's been raining, or making this excuse and that excuse. So
So they observed it from your
They
vantage
did.
point in your unit.
they did. And I don't remember the exact date, but it was just a few days after June 25th.
Okay.
So,
So they're very well aware of
They're
what
very
is
well
happening.
aware.
I got it.
and so
And,
they,
and also just for clarity, Tom Walker Plumbing was hired by the condo association or
they were contacted by Deborah Carroll for the condo association.
okay. And so Ludmilla was not the one who hired them, and
Nope.
so was Tom Walker Plumbing. I mean, were they able to fix this themselves? I mean,
Well, they did not fix it because that would be Ludmilla's expense, and she doesn't want to incur that expense.
okay, well, she's going to incur greater expense at the rate this is going.
Right.
Okay.
So basically, we've been ghosted, as the
Okay.
modern term, and that's where we are. The leak has gotten worse, and we're at the point now where my wife doesn't want to even use the shower because it's dripping down quite a bit.
Incredibly frustrating situation, and the authority that I have is to impose fines on the property owner and her property. And so, anything further before I ask Officer Costa back?
I would just be very grateful to have this thing resolved, have
Of course.
the plumbing repair fixed to code and the drywall, returned to our ceiling.
Okay. That's all very reasonable. And we'll see if an order gets her attention.
Thank you.
So,
Thank you.
thank you. Officer Costa, what is your recommendation based on everything we've heard?
Based on the testimony and evidence submitted to this hearing, staff respectfully request that the magistrate find the respondent in violation of the notice of violation and give the respondent until October 23rd, 2023 to bring the property into compliance.
Okay. They're in violation of certain provisions stated in the notice of violation. Is that what you intend to?
Correct.
Okay. All right. So I'll go by the provisions that were set forth in the notice of violation then. And the compliance date. So what we need is to apply for, obtain the business tax receipt, and to get this fixed. And then the compliance date again was October 23rd?
Correct.
2023, okay. Let me give you the outline of an order here this evening. Find that Ludmila Chistakova is the owner of the subject property. I find that various inspections were conducted by Officer Costa, and that he had access to Unit 1 down below and was able to observe the leaking shower drain fixture in the ceiling that has caused substantial damage, and it's turned into a nuisance to the property owner below. Was there any determination that work was done without a permit?
There hasn't been any permits that were applied for.
Okay. So when you're pointing out, though, the inadequacy of the pipe size, I mean, was that work done without a permit, do we know, or is that just not before us this evening?
I'm not sure when the work might have been done.
Okay, but we're not, that wasn't part of the notice of violation, work done without a permit?
I don't believe there was a permit for that work. I think her boyfriend did that work.
Okay. Do you mind if I'd like to get that on the record. Would you care to come back to the stand here, Mr. Cardarelli? Did I pronounce that
Yes.
right? Could you just state that because it was not clearly on the record?
Okay, my understanding is there was no permit pulled 5 years ago approximately when the initial repair was done.
Okay. Thank you very much for
All right.
stating that for the record. All right. So my question to you, Officer Costa, is whether was that part of the notice of violation?
No.
Okay, so we're not gonna proceed on that tonight. Maybe that's something for a future proceeding. I find that the shower drain was installed improperly, does not meet required code, and is again causing damage and a nuisance. I find that the subject property has been listed by the owner as a vacation rental. However, she has not applied for, and the city's not issued a business tax receipt to allow for the lawful rental of the unit. I find that that the notices of violation, the notices of hearing complied with Section 2-253 of the City Code, as well as Florida Statute Sections 162.06 and 162.12. I find the respondent is in violation of Section 70-69 that pertains to the requirement to procure a local business tax receipt from the city. Anyone, that is, who is performing or offering to perform services, sell goods, advertise goods for sale, perform services, solicit, advertise the performance of services of any business has that requirement, and surely this falls under that requirement of 70-69. I would note that the Florida Building Code has been adopted by the City of Cape Canaveral, Section 82-31. I'm finding a violation of Section 504.1 of the International Property Maintenance Code, which states that plumbing fixtures shall be properly installed, maintained, in working order, shall be kept free of leaks and defects, and be capable of performing the function for which such plumbing fixtures are designed, and that they shall be maintained in a safe, sanitary, and functional manner. Finding that the leakage has caused a hazard in the destruction of the ceiling in the lower unit, and so that I'm finding that there was a violation of Section 504.3 of the International Property Maintenance Code. I'm as far as going back to the Florida Building Code, Section 704.2. The code specifically states that there shall be no reduction in size in the direction of the flow, and so there's a clear violation of that provision of the Florida Building Code. So I'm going to order the property owner, Ludmila Chistakova, to have a licensed contractor contact the City of Cape Canaveral building permit to apply for and obtain a permit to replace the shower drain assembly. And that once all work has been approved and completed, that a final inspection shall be required, that it is the obligation of the respondent to ensure that all inspections are performed. Ordering the respondent to apply for and obtain the business tax receipt. And the respondent shall have until October 23rd, 2023, in which to fully comply with the terms of my order, which will be entered in writing. It's entered here tonight and will be placed in writing this week. And I would just direct staff, if there's a failure to comply within the time limits set by the order, that you shall schedule a compliance hearing before me for the issuance of fines in accordance with the Massey decision. And that in that proceeding, I would consider the imposition of fines of up to $250 per day for first violation and $500 per day for repeat violations, and that any fines may become a lien in favor of the city on that subject property and upon any of the real personal property of the respondent. And also, given the use of the unit as a vacation rental, I'm making a finding of fact that this was not homestead property. And non-homestead property can be subject to foreclosure. Is there anything further on that matter?
No, sir.
Thank you very much, Officer Costa.
Thank you.
All right. The second matter this evening is case number 22-054. It involves 521 Jefferson Avenue, Richard Stark and Margaret Stark, and Tyler Stark property owners. Will allow for Mrs. Stark to join us by telephone.
Hello?
Hello, Mrs. Stark.
Yes.
Hi, this is Patty at the City of Cape Canaveral, and you were on the speaker, okay?
Yes. Thank you, Patty.
Thank you.
All right.
Can you hear her?
I can hear her. Mrs. Stark, are you able to hear me?
Yes.
Very good. All right. And then I think it's important, whoever is speaking at the podium, to make sure that our voices are heard over the sound system, so Mrs. Stark can hear what is
You asked us to
transpiring
remind
here.
you to swear her in.
Thank you so much. Mrs. Stark, would you please stand and raise your right hand? And I'm gonna take you at your word that you're doing this. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you very much.
Can I say something?
Yes.
Mrs. Stark, if at any time you can't hear the magistrate or Officer Robinson, please let us know, okay?
Okay. It's a little muffled trying to hear the magistrate, but I can. I just have to really straighten to it.
All right. Mrs. Stark, is my voice muffled?
Mrs. Stark, did you hear the magistrate?
I did. It's a little difficult to hear, but I am hearing them. It's a little muffled.
All right. Is there anything else we could technologically do that can improve the sound quality that she hears?
I can't get it any further down. This is as far as it'll go.
Okay. So I'll just try to do my best to hear. I'll tell you if I didn't hear.
Mrs. Stark, is the sound quality any better?
I'm sorry?
Maybe that response answered my question. I asked if the sound quality is any better now that we repositioned the telephone.
Yes, I can hear. Like I said, it's a little muffled, but I can hear. I just put earplugs in, so it makes it a little bit better.
I think we're just going to have to do the best we can, unless you have any suggestions.
My kids are watching this on YouTube right now, so it's just incredible how there's this difference, but I know that we'll do the best we can. Just ask that again she can't hear anything because I imagine I'm going to be.
Yeah, she probably cannot hear you now because you're not at the speaker.
Just for
But
the record, just as long as she knows.
nothing's on the record unless you're at the podium. So I'll tell you what, if you can come to that microphone right there, is that microphone on? And if you just repeat what you said, because anything you state without a microphone is not being recorded. So go ahead, sir. If you'd please state your name and address for the record.
Okay, so my name is Jacob Stewart. I am Ms. Stark's lawyer and the Stark family's lawyer. My address is 1601 East Amelia Street, Orlando 32803. So Ms. Stark, as you were just told by the city clerk, that if at any point in time you cannot hear the proceedings, you need to let us know, all right?
Yes.
Okay.
All right. Thank you very much, Mr. Stewart.
Yes.
All right, I'm going to turn it over to Officer Robinson. If you'd please introduce yourself for the record.
Officer Robinson, Cape Canaveral Code Enforcement Officer.
All right. So what do we have before us this evening, Officer Robinson?
This is the compliance hearing for 521 Jefferson Avenue in Cape Canaveral, reference the property density for the 4 units.
Right. And just to refresh my recollection, there was a unit in the rear. There was a unit upstairs.
And
There were 2 units
in
down on the first floor. One was in an addition to the house, if I recall correctly. And the order that I entered, I believe I amended it just to clarify which unit where the kitchen facilities had to be removed. I think that was on February 20th, 2023. And then one unit was grandfathered, and that would have been the one out back. Is that correct?
There was one that was administratively approved. The property can only allow 2. 3 was administratively approved.
Okay.
So the 4th one was well above and beyond.
That's what the issue was. Oh, all right. Okay.
So yeah, once again, this is about the density and then the removal of the kitchen.
Right. Has the kitchen been removed?
No, it has not.
Okay.
Notice of hearing, 8/28/2023, return receipt 9/1/2023 to the Starks. The property was also posted on 8/28/23. I also sent an email to Jacob Stewart on 8/29/2023.
Okay, just hold that slide there so I can get these dates. And the City Hall was also posted?
Yes, sir.
Thank you. And then 29/23. All right, go ahead.
On 8/4/2023, staff checked on the status of the appeal of the magistrate order and found the case had been dropped by the Starks on May 22nd, 2023.
When you say the case was
They
dropped,
appealed your decision,
all right, so the appeal was then
voluntarily dismissed.
voluntarily dismissed. All right.
I
Do,
checked
do we know the date that the appeal was dismissed?
May 22nd of this year.
1 second. Yeah, one of my first questions when this came back was whether I had jurisdiction. Because the appeal's been dismissed, I find that I do have jurisdiction to hear this. So you may go ahead.
Check of the city's database found no permits for the demolition of the kitchen had been obtained. Research into several vacation rental sites revealed the property is still listing 4 separate units for rent. On 8/7/23, staff contacted Ms. Stark about the continued violation of renting a 4th unit and the kitchen still remaining. She stated we would need to speak with her attorney. Staff generated a notice of Massey hearing and sent it to Ms. Stark. On 8/16/23, staff spoke with attorney Jacob Stewart about the violations. He stated it was his understanding the kitchen had been removed and there have been no rentals of the 4th unit since the magistrate order. Staff conducted a search of rental sites like VRBO, Airbnb, along with YouTube videos, and informed Mr. Stewart of the results. Staff also explained the permit requirements for the unpermitted 4th kitchen.
All right.
I'll get to those results
Can
in a
you
moment.
can you just back up to that slide? I want to make sure I get all this. So so when it says staff contacted Mrs. Stark, was that you?
Yes.
Okay. All right, and so this search that was conducted on 8/16/23, are you telling me that there were 4 units that were still being advertised?
Yes, sir, and I'll show you that later
All
on
right, so
later slides.
this is, all right, approximately a little more than a week after you had spoke to Mrs. Stark on August 7th, correct?
Yes, sir.
All right, you can go ahead.
On 8/17, staff received an email from Mr. Stewart advising that all advertisements will be updated to reflect only 3 units are available for rent by 8/18/23. Arrangements were also made to inspect the property on 8/21/23. That would be for the removal of the kitchen. On 8/21/23, staff conducted a site visit of the 4th unit and found there was still a refrigerator, sink, cabinets, microwave, and toaster oven remaining, and what can only be described as a kitchen. All unpermitted plumbing for the sink and refrigerator, as well as the unpermitted electrical for the refrigerator, microwave, and other outlets remain intact, and the unpermitted 220 for the stove oven remains. On 9/26/23, today, a check of the vacation rental sites has revealed the property is still advertising 4 villas for rent. YouTube is also advertising 4 villas. There has been no demolition permit obtained to remove the 4th kitchen.
Pull the slide so I can get all this. So I recall that my order said to remove all cooking facilities and to remove the kitchen, including all cooking facilities. Was that a?
The order states remove the non-permitted kitchen in the addition for the first floor of the main structure, including all cooking facilities.
Okay,
Removal of the non-permitted kitchen shall include removal of all cooking facilities. Respondents are advised to work with the city building department to pull any necessary permits and allow all inspections.
okay. All right, so it's the city's contention then that the, the refrigerator and the microwave and the sink, those are all parts of.
I will
of
show you
a-
the pictures that I
All
took
right.
on the inspection.
All right, that's fine.
I don't know how difficult this is going to be for you to see, but
can see
this is about the space that you get on the Airbnb websites, and it discusses everything. And if you go down to where it says the space, the middle paragraph, about halfway down, it says the villa is part of a 4-villa complex. So this right here was what I found in early August that prompted the compliance hearing to be sent out.
All right, so this is on Airbnb. And what's the date that you observed, that you
This was
captured this?
approximately just before I contacted her, so somewhere around the 5th of August to the 7th of August, somewhere in there.
Okay. All right, and it does say stay in 1, 2, 3, or all 4 units as well?
Correct.
Okay.
Yes.
And then further down, if you go back to that slide, then it says villas 2, 3, and 4 are also spectacular. Okay.
These are photographs that I downloaded off of Airbnb on that same date and time. Same date and time. I'm just showing how they've got the 4 villas advertised.
All right, so what I'm concerned about here are kitchens. And so I do see a full kitchen 1.
Well, right now I'm just showing you that there's still 4 villas. I haven't gotten to the kitchens yet.
Oh, I do see, okay.
I'm just
see.
showing that
I
the
see.
Airbnb is reflecting that there's still 4 villas.
Oh, I see 4 bedrooms.
This is just one villa right now. There's 4 separate advertisements
Okay,
that
okay.
they have.
All right, and so this is, I see. So this is all,
This is just one right now.
all right, okay.
This is Villa 4.
That's the unit in the back,
That's the shack, the shed, whatever you want
the
to call
shed.
it.
I think we were calling it the shed.
And this is just on the Airbnb site itself. The 2-story building in the middle there to the right with the blue trim. That's the one we're talking about.
Where it says guest house in Cape Canaveral, 4.74 stars.
Yes, sir.
All right.
Now this is the kitchen that we are discussing. This was a photograph that I took on my visit on the 21st. As you can see, there's a refrigerator, there's a microwave, there's a toaster oven, there's outlets, there's kitchen cabinets. For anybody looking at this is still a kitchen.
Right. Was there any, and is there a stove there as well?
There is no stove, that's been removed.
So stove was removed, but, okay.
And I'm just going through all the detailed photos you can see in there. There's outlets right there along the wall. Those are all unpermitted. There's a toaster oven. There's the microwave. The stove was initially below it. And then there's the photograph of the 220 outlet. And the only thing that you would use a 220 outlet for would be a stove or a dryer. And this is not a laundry room.
And so is it the city's position that the 220 volt outlet should be removed?
It would need permits because it was never permitted in the first place.
So you would need you need a permit to remove it, correct?
A demolition permit because it needs to be removed properly to ensure that we're not going to have a fire hazard. Since this is a rental property and there's 3 other units, this needs to be done professionally.
All right, and then I think a microwave is clearly a cooking facility. And then what about, does a refrigerator require 220?
No, sir, that's a regular.
Okay.
That's a regular 110.
Okay. Does a refrigerator fall into the category of a cooking facility necessarily, or?
We believe that everything in here, this is still a kitchen.
Yeah.
And the kitchen needs to be removed.
Well, I mean, you could have let me just, for sake of argument, I know people who have, a freezer in their garage, for food storage, that sort of thing. Is that a regular refrigerator, freezer, or? It appears to be, correct?
Yeah, it looks like a standard residential refrigerator to me.
Right, so we have a
And
refrigerator.
our contention is that when you look at this, it looks like a kitchen still. It acts as a kitchen. It's still functioning for meal prep, for cooking the food, for storing the food. There's a dishwasher in there. Dishes are used for eating food. So everything about this is still a kitchen. Okay, these are what I downloaded off of Airbnb today. This is the guest house, the shack again.
Okay.
And then if you look at this where it describes the space, and it says there are 4 villas on the property that share the picnic and barbecue area. So it's still saying that there's 4 villas on this property.
This is today?
This is today.
And just for the record, today's date is the 26th of September, 2023. All right.
And then this is the main house that I saw. And then you do the same thing. And this one says Laughing Dolphin consists of 4 private villas on 1 property. Still saying that there's still 4 villas here.
Okay.
This is Margie Stark's YouTube page. And if you look, the one is highlighted in red, and then the 3 that follow are all hers. And they talk about each space. And then I've got them individually photographed and named. This is the villa. This is the Beach Retreat Unit 1. Captain King's Suite Unit 2.
Hold on. Captain King's Suite?
Captain King's Suite Unit 2.
Okay.
Sunrise King's Suite Unit 3. And the Surfing Shack Unit 4.
Which is the bottom unit that is in the addition that
I
we're concerned
don't know. I don't know how they've determined which one is which.
Okay.
I mean, if I watched the videos, I could probably figure it out.
Okay. Right.
But we maintain that they're still advertising for 4 units based on just the Airbnb and the YouTube videos. I understand that some of these have been posted for quite some time. The YouTube videos, they say 3 years ago, but it's still actively advertising that this property has 4 units. It needs to be removed, redone, however they want to do it to reflect only 3. Now, they used to have 4 listings on Airbnb, 2 of which did say that there's only 3 villas available. So I don't want to sit here and say that they haven't tried, but it appears that they did change 2 of the 4 to reflect that there's only 3 villas. And then the city maintains that the kitchen is still a kitchen. It could still easily be rented out as a kitchen, and we want it to be gone so they can't continue to rent out 4 villas. So that's what the city's at.
So as far as the removal of facilities from the kitchen, I'm trying to understand what exactly I think we discussed that the city would want a demo permit to remove the 220 volt outlet. You would want removal of the refrigerator. You would want removal of the dishwasher. You would want removal of the microwave and the toaster oven. Is that correct?
I guess they could. I mean, the sink. If the sink remained and they just had it as a wet bar or something, the city would be fine with that.
Okay.
But a kitchen for meal prep and cooking is what we're talking about.
Right. All right. Anything further before I hear from Mr. Stewart?
No, sir.
All right. Mr. Stewart, if you could reintroduce yourself for the record.
I'm sorry, you said Mrs. Stark, something about the record I didn't hear.
Mrs. Stark, what did you just say?
That's as far as I can move it right there.
I just heard Mrs. Stark. I couldn't hear what else you said after that.
Ms. Stark, can you hear me?
Yes.
Okay. So again, my name is Jacob Stewart. I represent Ms. Stark and her family, because in the actual complaint, it's her husband, herself, and her. Mr. Geller, before we move forward, when I asked, in the notice of hearing that we got about this today, I'd requested in writing what the actual alleged violations were in terms specifically. I've heard 2 of them mentioned now from the testimony from the city. In the hearing before, there was a mention about ProChamp, and one of the allegations was from the city. In an email I have from the city when I was asking for essentially for them to specify, and this is from Mr. Palmer on August 22nd, 23, the third contention they were saying for purposes of this hearing today was that she had failed, me and Ms. Stark had failed to register with ProChamp. I know that it was on the record beforehand, but just for clarification, I want to make sure that the city's not moving forward with that because of their bankruptcy.
That's a fair question.
We are not.
No, that's not part of this. They're in
All right.
compliance with that at this time.
Okay, there you go. There's one down.
I had a whole thing of judicial notice to do with you, so.
You got one down, so go ahead.
So, I've just got I think there's, based upon the standard of evidence that we have here, I just think there's 2 things before I make a brief opening statement, if I will.
Sure.
I was hired and brought on after the main evidentiary hearing had occurred before you, and you entered your order back in February of 2023. Ms. Stark and her family, pro se, made an appeal to the circuit court, and I was brought in on an order to show cause from the court based upon a functionality of, I think, how the appeal was done. Yeah. We decided, without me breaching attorney-client privilege, it was in our best interest to reset that, and the plan was, beginning with me, my law firm being retained, and with me is my legal clerk, Mr. Bullock, who's pending the bar results, which is always very exciting. We knew that based upon your order, which was very clear, it said that the code enforcement does not have the jurisdiction to allow the 4th unit to be grandfathered in. We'd have to seek that from the city council.
You would.
And my recommendation from the beginning with Ms. Stark and agreeing to represent her with my law firm was to go about and say, if we're going to do this, we need to do it the right way and approach the city council to do it the right way. While researching and preparing a petition to go to the city council, we got word that there had been a violation that happened. So that's how this kind of all tumbled here. Mm-hmm. So when there was evidence being brought up about conversations and things, I was not even aware of the alleged violations until being made aware of that, and that's how we kind of got to where we are now.
Okay.
So I think that's relevant because from our points now is that your order is exceedingly clear in the advertising issue specifically. And I'd like to bring up one of our witnesses, if I may, Mr. Gilmer, to actually, or Geller, to allow her
Sure.
to testify, and if I may directly kind of.
Sure,
direct her.
and either she can speak on her own, or if you want to question her, however you would like to proceed.
If I just may ask her a few questions.
Sure, and then as you do so, if you just make sure you're speaking into the microphone so Mrs. Stark can hear. Could you please state your name and address for the record?
I'm Lauren Barley, 1 North First Street, Unit 5, Cocoa Beach, Florida.
Your first name is Lauren?
Yes.
Lauren?
Yes, sir.
Lauren Barley, okay? All right, Miss Barley.
Mr. Geller, may I have permission just to use
Of course you may.
So, Ms. Barley, not to invade your personal space in post-COVID, but I just want to make sure that Ms. Stark can hear us all the way.
Yeah, I want to be able to.
Go ahead and invade her space and get close to that
I was told
microphone.
I need a hearing aid, and they said it was 9,000. I said, forget it.
Okay. So, would you please tell Mr. Geller what your association is to Ms. Stark and her family?
Yes, I'm a real estate broker in Florida for 32 years.
Okay.
I've been the property manager for Margie's property for probably 3 or 4 years.
Okay.
I don't know exactly when.
And so for clarification, because this is a record, by Margie, you mean Ms. Stark?
Oh, Miss Stark, yes.
I know exactly who you're referring to.
Okay.
That's fine.
And so being a property manager, tell us, that means specifically for the vacation property that's subject of the hearing today?
Correct, and many others. I manage many properties, not
Okay.
for Margie Stark though, just,
Just this one property in question?
yes, 521 Jefferson.
Right. And as part of your responsibilities of being property manager, do you manage the online advertisements?
Correct.
All right. And were you paying attention to when the hearing officer was presenting his PowerPoint about dates and things like that?
Yes,
In terms of August and of 2023 and modifications to even as of today, September 26, 2023?
yes, I did hear that.
Okay. Now, to your knowledge, being independent, what does the current Airbnb advertisement reflect for the property that you control for Mrs. Stark and her family?
Okay, the current advertisement I have is Unit 1, which consists of the entire bottom first floor building, which is advertised as 4 bedrooms, 2 parking spaces, 1 kitchen, and 2 bathrooms, I believe.
Let me get this. So 4 bedrooms, 1 kitchen, and 2 parking spaces.
Correct.
Okay? I got it.
Is there any, since I know there's some clarification of issues, was there an inadvertent advertisement left up on Airbnb showing that the 4th villa was available when in fact it was not?
Yeah, well, first of all, to clarify with the villas, there's Villa 1, which is the first floor. There's Villa 3, which is, separate. It's the second floor. And then the one in the back. The villa in the back, first of all, on Airbnb, they never have addresses. So if there was a typo there, it was a typo because Villa 4 has nothing to do with the rest of the property. It's a separate listing.
Well, you're calling something Unit 4 that implies there were 3 other units. I think a reasonable person looking at that would assume
Yeah.
that. So nothing is currently being advertised as
It's not
Villa.
called Villa 4. See, in my head, I've had this property for 3 or 4 years. So in my head, that's what that one is. It's a surf shack. So the surf shack is advertised separately from the rest of the property.
But-
It's not part of the Villa 1.
I didn't mean to interrupt you, but for clarification and his specific question, I want to reiterate that because it's important.
Okay.
Is that currently right now, you cannot just rent Villa 4 by itself, correct?
Well, no, the surf shack is considered what I used to think Villa 4. So the main house used to be, before the city told Margie to change it, it used to be 1 and 2.
Okay.
Okay, now it's just 1.
Right, that's what I'm trying to get at, is that as of now, advertising, you can only rent the whole thing as 1 unit now, correct?
Yes,
Okay,
correct.
That's what I'm trying to get on the
Right.
record to be
Yeah.
specific. Now, since February of 2023, when Mr. Geller entered his order as a special magistrate to current September 26, 2023, has anyone rented the property?
Has anybody rented the property,
Like-
the main house?
Yes, the main house.
By itself?
Yes.
No.
Right. but there's been one, though, person, my understanding is from June 6th, if this refreshes your recollection, from June 9th, 2023 to July 22nd, 2023, the main house, that's the only time it's been rented out, and that was to one family for 43 nights in a row. Is that correct?
Correct, and it was the entire property.
It was the entire property. But my point is to make sure that Mr. Geller understands what I'm trying to get at, from my point of view, is that there has been no one or no advertising from your perspective trying to show an individual, and you've now, since we've been notified, relabeled Airbnb to reflect that. Is that correct?
Correct.
All right. Do you have, when you're doing a property manager, sometimes when you list something, is it hard to take down a posting, meaning like an old YouTube video or an old Facebook post or Airbnb post?
Yes, I've never even seen that YouTube.
But my point being, though, is that
It's hard to get it down, yes.
sometimes when something gets out on the internet, even if you modify or amend it, you may not be able to control it, or someone still may be able to see it.
Correct.
As we stand here today, and you saw before the hearing officer, is there any mention of 4 villas on the current posting of Airbnb right now?
No.
Well, I saw references to 4 units, to 4 different villas. So you're telling me what I saw I didn't see? I'm a little taken back by
I
that.
gave him a screenshot. I just looked at my phone.
So is the testimony that Airbnb has now been remedied, so it no longer is referring to 4 villas?
I didn't see it when he put that up there. I didn't see it, so I looked on my phone and it does not say 4.
But you need to talk into that
Yeah,
microphone.
if you could please repeat what you said, and so go ahead.
When I saw what was on the screen, I was like, that can't be possible. So I looked. I have the app right here.
Okay.
I looked and it did not say that. So I'm not, arguing with anyone, but it didn't say that here.
Okay.
So I sent him a screenshot.
All right. But then as far as YouTube goes, you were not familiar with that until this evening. Is that correct?
What?
You were not familiar with the YouTube listings until this evening?
Correct.
Okay. And so if the YouTube is indicating what it appeared to indicate, that would have to be remedied going forward. Is that right?
Correct.
Okay.
I'm the only one that has rented the property assisted in a rental for 4 years. So
Okay.
I've never had a booking from YouTube.
But it appears to be advertised, though, on YouTube, from my looking at the evidence so far.
Yeah.
Okay.
People advertise everything. You'd be surprised how many of the short-term rentals I have that other people have put ads up and actually tried to take money.
Okay, let's focus on this property here. Okay. Go ahead, Mr. Stewart.
If given the opportunity by Mr. Geller in this, quasi-judicial proceeding to clarify the language to be in complete compliance, would you have the ability to do that?
Sorry, it doesn't pick you up.
Yeah.
If given the ability to be in complete compliance, if Mr. Geller were to allow us to modify the language, would you be able to do that in a really quick manner, like within 24 business hours?
Yes, I could do it in 5 minutes.
Okay.
All right. I have no further questions, Mr. Geller, for her.
Okay. Thank you, ma'am. Do you have another witness for me to hear?
I'd like to direct examine Mrs. Stark.
Of course.
Ms. Stark, can you hear me?
Yes.
All right. At any point in time, if you can't understand me, please let me know. Mr. Geller, may I proceed?
Okay.
You may.
Okay.
Ms. Stark, I want to stick to, like we talked about before, what is directly asked of us, all right, for purposes of the hearing today? All right?
Yes.
All right. Were you able to hear the testimony from the code enforcement officer who testified before I was at the podium?
Yes.
All right. And were you able to see any of the pictures or the exhibits that he actually put up on the screen?
I did not. I don't have a visual. I'm just listening.
Okay. But prior to today, you in fact allowed code enforcement to go into your property and to inspect your property that's in question. Is that right?
Yes,
And that was on August, I think, 22nd or 23rd of 2023?
yes, my daughter was there to let him in.
Okay. And you saw the pictures and video from that date when the code enforcement officer was there at your property. Is that correct?
I don't recall. I don't recall him showing me pictures.
No, that's not what I said. I said, do you recall seeing the pictures and video of when the inspector was at your property in the villa that's at question?
Are you talking about pictures that he's showing there right now that he took? Are you talking about that?
Yes,
Did
I'm
I see that?
Remember
That
when?
Mr. Robinson took?
Yes, ma'am. The ones that we
He
sent.
didn't show me any He didn't show me any pictures, no.
At any point in time, though, did your daughter, when he was there inspecting it, did she videotape what he was inspecting in the room?
Yes, my daughter did.
And did you see that video that your daughter made?
Yes, I did.
Okay. Now, after Mr. Geller entered his order in regards to this case back in February of 2023, was it your intent to comply with the order?
It was, I absolutely wanted to be in compliance, yet that's why I sought to find an attorney, and then I found you because I felt that I wanted to keep the property the way I thought I had purchased it. And that's when I had come to you. Other than compliance, I was looking to be in compliance in any way. I took the listing right away off. I quit. I even have hardly even rented it out. I just was so worried about renting it out and doing something that was not in compliance.
Ms. Stark,
We took the stove out as was instructed. That was the only thing that they told us.
Well,
Mr. Robinson told me the stove, and Dave Dickey told me.
Ms. Stark, would you
Oh,
just?
Maria?
I think we're getting beyond the responsiveness to the question.
Yes, I
So,
was in compliance.
Mrs. Stark,
But
if you would
it's my best
just,
to be in compliance.
Mrs. Stark, if you would just wait for the next question from your attorney, please.
Ms. Stark, like we talked about, Mr. Geller's talking about something called the narrative, meaning you're going beyond the scope of the question. We're looking for very specific evidence. It's fine. I know that you have a lot to say, but there's only certain things for purposes of today we want to talk about. I'm going to respect everyone's time, all right? After the order was entered, part of the compliance of the order was for you to remove cooking faculties from where the area was in question. Are you familiar with the section of the order that I'm talking about, Ms. Stark?
Yes.
And part of that was also is that you were to be in coordination and to talk to the city of Cape Canaveral and coordinate with them their approval of removal of whatever cooking appliances that they deemed appropriate. Is that correct?
Yes.
Did you talk to somebody from the city of Cape Canaveral after Mr. Geller entered his special order in relation to complying with the kitchen issue?
I did not.
It's my understanding that you spoke to somebody by the name of Mr. Dickey. Is that correct?
After magistrate's decision, no, I did not talk to Mr. Dickey at all. Prior to that, I did, and prior to that is how he instructed me.
And what did he instruct you to do to be in compliance?
And just to be clear, that this
and
is,
sign up for pro champs, and we're golden, is what he said.
and just to make clear that this conversation
And
with
then
Mr.
rent the whole.
Mrs. Stark, if you'd allow me to.
You can only rent out 3 units.
Mrs. Stark, if you'd allow me to just, I need one bit of clarification that this conversation you had with Mr. Dickey occurred after entry of my amended order on February 20th, 2023. Is that correct? Mrs. Stark, did you hear my question to you?
No, I'm sorry, I did not.
Yes. The question is, did the conversation that you are recounting with Mr. Dickey, did that take place after the entry of my amended order in this case?
call.
Okay, thank you.
Okay. In that, well, let me ask you this. Why there was an oven in the kitchen, or the kitchen area where we're talking about, before the order was given by Mr. Geller, is that correct?
The oven was in the kitchen before Mr. Geller. Yes, it was.
And you, to be in compliance with what you believe to be the order and to be in compliance with that language, you had the oven removed from there, is that correct?
Yes.
Why would you think that removing the oven from there would make you in compliance with the order?
Because that is what Mr. Dickey told me and Mr. Robinson told me.
Okay.
With
And-
Mr. Dickey, and who was the other
Remove
person?
stove, remove the oven.
I didn't mean to interrupt you, Mr. Geller.
I was just trying to understand, she spoke with Mr. Dickey as well as another person. I missed the name of the other person. Ms. Stark, who was the other person who told you to remove the oven other than Mr. Dickey?
Mr. Robinson.
Oh, Mr. Robinson. Okay, Officer Robinson, I got it. Okay.
And Ms. Stark, were you able to hear the testimony from Ms. Barley at the podium before you were called as a witness?
Yes.
All right. And I want to make sure that there's clarity. After there was an order, the order was entered by Mr. Geller, did you in fact ask Ms. Barley to make sure that that you complied with his order in terms of advertising?
Yes. Right away.
And since the order was entered in February of 2023 by Mr. Geller to date to September 26, 2023, has there been any individual rentals of the units? And to be clear for the record, meaning that one person would rent like Unit 3 or Unit 2 and like different individuals? Has there been any of that that's happened since the special order has occurred?
No.
Is it true, in fact, there's only been one rental of the entire main house for 43 days during the summer of 2023?
Yes, I do believe. Just the guys that were there. All together as a group.
Do you, Ms. Stark, in terms of, I know you couldn't see some of the postings, but when you became, do you remember, and please answer my questions directly, back in August of 2023, when I became aware of postings on Airbnb about the villas and different villas that we thought may be in violation of Mr. Geller's order, were you aware of those postings at that time when I spoke to you?
No, I was not, because Lauren and I had talked, and it was taken down immediately.
And was it after
Lauren,
that?
my property manager, and I had talked, and we only rented, changed the wording so it was in compliance to what Magistrate wanted us to do.
So my point is, though, is that you weren't, it's this, was it your intention or your husband's intention or your son's intention, the property owners of this property here in Brevard County, was it your intention to circumvent Mr. Geller's order?
Can you clarify what you're meaning, circumvent?
Meaning, did you attempt to do anything to violate his order intentionally?
No, we did not want to violate his order at all.
Is in fact the reason that you hired a lawyer, my law firm, to try to get yourself on the right side of this with the city of Cape Canaveral. Isn't that correct?
100%.
All right. Mr. Geller, I don't have any more questions for her relations to today.
Right. Any other witnesses?
No.
Any argument you'd like to give me?
Essentially, since the pro-champ thing's been narrowed down, we have the two really main issues. The advertising issue, which I think the evidence concedes objectively, there was an inadvertent violation.
Okay.
And I think, Mr. Geller, the intent is critical in the situation. If there was evidence to suggest that the individual units had been rented out, or that they were attempting to circumvent your order, I think that would go towards more likely than not that she should be subject to a fine. But I think that you have someone here, Ms. Stark, who is relying upon a property manager, who has now engaged a law firm, who as soon as they found out of the violation or potential violation in advertising, wanted to correct it. And even if it's still not correct today, I would hope that you would consider allowing us a grace period to correct that and allow it to be satisfied to your liking or to what you find to be appropriate.
All right. Anything else on the advertising issue?
I think there's some inconsistent evidence in terms of, when the timing of things happens, but I think that from the August 17th or August 16th, 2023 snapshot that was showed, I think that's objective, and I think it was just done inadvertently.
All right. Let's move on to the kitchen. It looks like a kitchen to me. So what say you?
Well, not to feel like I'm in a law school class, I think I would argue, you kind of started to allude to it, Mr. Geller. Let's say that someone is outside, and let me ask this. Wet bars are permissible, right? A wet bar has a sink, right? A wet bar.
Right, and the city is saying they have no objection to the sink remaining. And so I think the concern is we have a refrigerator, a dishwasher, a toaster oven, and a microwave oven, and we still have the 220 volt connection for the oven or stove that had been removed, and which was unpermitted, which was also part of the mix.
Right, as part of your formal finding from February of 2023, that was done by let me rephrase that. Much of that was done by the prior owner. Some of that had been done in relationship, or some of the repairs have been in relationship to the hurricane. I think
Right, and I think my order found that the Starks were not responsible for the non-permitted work. I think my order, I found as a matter of fact that it was the prior order that did the unpermitted work, because we had the handyman testify, and he was very sincere and compelling to me, and but I think when I say it was all kind of mixed in here is that we do have, they were still built with or installed without permits, and so part of the position of the city is, well, you got to remove that outlet because it was put in without a permit. I think that makes sense to me.
I understand, Mr. Geller. I think from the testimony that we have today from Ms. Stark's point of view, she relied upon conversations she had with the city that told her, from her perspective, that as she removed the oven, the main cooking appliance, that she would be in compliance. Okay. I understand from my conversations with the hearing officers or the code enforcement officers since we found out about this, and from our email correspondence when I asked them to specifically demonstrate or show me in either municipal code or Florida statute where the issue was, the question was whether or not the level of demolition or change should occur to that room. And so I think going back to your analysis about what's allowed and what's not allowed, I think the law is unclear about that. I think that in the sense that what really makes a kitchen. Now, I think
I'm not sure it's so unclear. I mean,
well,
I think that's very, very typical for a municipality to count the number of units based on kitchens. I mean, that's just as long as I've been working with municipalities and Orange County, that's how it's done. So I'm not sure the lack of clarity.
Well, but there's been
I'm responding to you so you understand what I'm thinking.
And respectfully, Mr. Geller, there's been no evidence to support a specific municipal code by the city that defines a kitchen. There's been no case law presented from the city's attorney, who I attempted to talk to beforehand, and who I ceased communication with hearing officers once I knew they had a lawyer to engage with them. I've tried on multiple occasions to speak to the lawyer to point to some case law or specific definition, because our goal is to be in compliance.
Okay.
So I think from my point of view that the burden is on the city at this point, simply putting up pictures saying, Mr. Geller, there's a sink, there's a dishwasher, there's a toaster oven, that's a kitchen. I think that's insufficient from a legal point of view.
Well, I do think that the code, and I have to find it, and I don't know if I even quoted it in my order, but I do think that there is a reference to cooking facilities.
There is, if I may.
And I think that in particular would be a...
I believe it's page 18.
Page 18 of my order, thank you.
Yes, where it's in relation to section 105.1 of the building
kitchen
code.
Yeah, I said the city reasonably determines the number of independent units in a multi-unit property based on the number of kitchens. And again, that's based on my my experience over many years dealing with how local governments count the number of units, and then. Okay, go ahead. I'll let you.
I think I don't want to be redundant or circular with my argument.
Sure.
I just, Mr. Geller, I respectfully think the evidence that's been presented today and the evidence that we have from Ms. Stark, I think that it's insufficient, that they have failed to meet their burden. If you do find that they have met their burden, Mr. Geller, I would ask you to consider allowing a grace period. It is our intent, and we held off on actually formally petitioning the city for another grandfather exemption until after this had concluded. You had allowed us the continuance beforehand. We wanted to have this hearing to see what the outcome would be, and then formally apply through city council to the proper chain. So again, just to reiterate for the record, we don't think there's sufficient evidence, but if you were to find there's sufficient evidence, based upon the intent and lack of intent from our point of view that is in bad faith, that we think that Ms. Stark and her family are acting in good faith. They've retained local counsel to help rectify this issue, to be good stewards here in the city of Cape Canaveral.
Thank you, sir. Anything further?
No, sir.
I'll let the city present any final argument, or there were some statements of fact, if you feel the need to respond.
Yeah, there's a couple of things. The photographs that I presented from Airbnb today, those were directly copied from Airbnb at around 3 p.m. today.
Okay.
So there was no manipulation there on our part. That's what was there.
I don't think Mr. Stewart suggested that any manipulation, and it appeared to state 4 units. So I agree. And then we also have the representation from the property manager that she would remove this within, well, she said 5 minutes, but I think 24 hours would be reasonable.
As for Mrs. Stark saying that we told her removal of the oven, I have not spoken to Mrs. Stark except for when I called her when I found that the violations were still continuing.
Okay.
I have not spoken to her since prior to the original hearing that we had.
Okay. And when you spoke to her, did you mention removal of the oven?
Yes.
Okay.
And she says, I just said the kitchen remains. We have not gotten any permits. And she said that, I thought that was taken care of. And then basically said that she has an attorney that I need to speak with. So I waited to hear from the attorney. David Dickey has not indicated that he has spoken to her since that time. Okay. The building official has not spoken to her. Nobody in our department has spoken to her since the hearing. And we were waiting and waiting. And May 22nd was when they had dropped their case. And I wasn't aware of that. And I just happened to go into my supervisor and ask what the status was. And he's like, oh, yeah, by the way, that's been dropped. So that's when I went, and that was in August. So that's when I started looking into things. Okay. So we hadn't been contacted at all. I was not privy to anything.
Okay.
And then as for the kitchen.
So when you spoke with Ms. Stark, did you mentioned removal of the oven? Did you tell her to remove anything else?
No, she basically just said I need to talk to her attorney.
Okay.
It wasn't a long conversation at all.
And did you, after that, speak with Mr. Stewart about
yes,
removal of other items?
We spoke in depth about it, and I said that, there needs to be a permit pulled because there was plumbing, there's electrical in there, so there needs to be a proper demolition permit, and that the kitchen still remains. All the microwave, the toaster, the refrigerator, everything that goes along with the kitchen other than the oven and the stove remains. And then the city's looking at it as, if this is one unit, then what is the need for multiple refrigerators? Because the other unit, I guess one unit now, has a full kitchen. So I don't see the need for all of these backup appliances, I guess you would call it.
Right.
So that's why we're looking at it as a kitchen. So, we understand. I think, May 22nd was when they were to come into compliance. We waited because of the appeal process to find out that, oh, by the way, on May 22nd also, they voluntarily dismissed it. Okay. So, here we are 4 months later. Okay. And
I would say, it was their right to appeal my order and their right to voluntarily dismiss it. I'm not going to hold that against them.
I'm counting from May 22nd when they dropped it to now.
Okay. And can you provide any information about how the city uses kitchens to count units? Is that a common
I'm not
type?
I'm not familiar with that. I mean, we look at it as if it walks like a duck, talks like a duck, it's a duck. I mean, that's how we're looking at it. There might be something in the International Property Maintenance Code that describes a kitchen. Off the top of my head, I can't recite that. But I'm sure there's something somewhere, either that or in the building code that defines what a kitchen is.
Yeah, I seem to remember, and I'm not finding it as I'm just going through this, that there is a code provision that does speak of cooking facilities, which would explain why I said including all cooking facilities in the order. I certainly got that from somewhere, and I'm pretty,
I
probably.
believe in both the building code and International Property Maintenance Code, it discusses food preparation requiring a sink, maintaining it in a refrigerator type environment to keep it fresh, cooking, all of that's there, I believe is described.
Okay, well, I'll look further at that since it was raised.
I mean, look, we're not.
Yeah.
The city is
What do
not.
you-
We're not wanting
what do
to
you-
jam them up or anything.
Yeah,
The city's still willing
they're-
to work with them to come
Yeah.
into compliance.
And from the evidence that I heard tonight, it's almost like no harm, no foul. They've not rented it to multiple people. You just had the one family that rented the whole house. You know, so what do you have a recommendation for me?
Well, I had the original
is this-
recommendation that they're in violation, but
Yeah,
that's
and-
entirely
and-
up to you.
Well, I think there are continuing violations of my order, and the question is, well, I think there are some mitigating factors here. You know, mitigating factor one is, well, this wasn't rented a whole bunch of different people renting different units. We had the one family renting, so no harm, no foul. That's the one mitigating factor. Mitigating factor two is she did remove the oven. I assume it's an oven stovetop type appliance. So there was some attempt there to comply. Mitigating factor three, you know, some of the Airbnb ads were removed. It just wasn't thorough enough of a job. So I see some effort to comply, but I also, from my vantage point, it looks like a kitchen still. And I think, you know, dishwasher, you don't need a dishwasher unless you have dishes. And so that is would be a sign to me that that's a kitchen. You know, it's a refrigerator freezer. It's not something that you're, you know, freezing a freezer alone, that you're freezing lots of, you know, food in bulk type thing. The kitchen, go ahead, I'll let you confer. The oven and the microwave, those are clear cooking facilities. I think those are clear violations of my order. Go ahead.
Like I said, we're open to a reasonable time frame to correct these.
Okay.
You know, we can wait till the October magistrate hearing, and
Okay.
if they're not in compliance by then we'll bring it back. You know,
All right.
we don't have hearings in November and December, so the next
Yeah.
one wouldn't be until January.
Right.
I think that's not.
All right.
I think that's a little too far out.
So what I'm going to do then, based on that, is I'm going to do a second amended order, and I'm going to give until how much time before that hearing that you need to verify these things?
As soon as they call me, I will go out.
Well, I want an outermost deadline before the October 23rd hearing.
Well, 10 days. I got to
10 days.
notify them.
So let's say by October 13, that's 10 days. I don't know what day of the week that is. I don't know if anyone has a calendar handy. It's a Friday? Friday the 13th, okay. So let's give additional time until Friday, October 13th, to come to compliance with the removal of all ads, with the removal of the microwave and the toaster oven, the removal of the outlet for the 220-volt outlet, the removal of the refrigerator, and the removal of the dishwasher.
And the permit to remove that 220.
Yes, so,
And
so,
if
so,
time is-
so,
if
so we,
there's
so
a
we want,
cons- if the
so, so
time-
we, so we want the permit at least applied for, or do you want it actually removed
Well,
by the
like I said,
13th?
if time becomes an issue on that permit, I'm sure the building official will sign off on the removal of it
Okay.
if the permit seems to be slowing things down. We
see.
can,
Work with
that's not
that.
an issue.
All right. Mr. Stewart, do you want to come back to the microphone and address anything? I've been having this conversation with just the city. Does that appear to be a reasonable outcome here, where your client has till October 13th to take care of this?
There's two things, Mr. Geller. I think it is a reasonable outcome. I think that my concern is that my client lives in Illinois. She has a property manager here. She has a handyman. She has her daughter who lives here who's pregnant. So I think there's some other factors. I think that if we, I'd like a little more time for them to do that, but I think at least applying for the permit is, in that time frame is correct. The other thing, though, I think just from a commentary point of view, Your Honor, sorry.
Oh, you can call me that. That's fine.
Is that when government in general comes in to tell us, remember, our property rights are some of our most sacred rights. So determining how many refrigerators or how many things is appropriate for a home, I think is a dangerous precedent.
Well, she couldn't, if there's I guess there's no garage, so that'd be, if you want to put a refrigerator in a garage, but it cannot look like a kitchen. Just, that's what the order was intending to achieve, was, one fewer kitchen to be in compliance with the zoning code, which is very clear. And
Yes, sir, Mr. Geller, I agree your order was clear in that regard. I think that I think the proposal that the city is talking about, I think, is reasonable. Obviously, I have to talk to Ms. Stark. I think just to be clear, though, with the language, you're asking for the refrigerator, but the microwave, the toaster, and
the dishwasher, and a permit to remove the 220 volt outlet. And there's no problem with the sink or the cabinets. And that can certainly be used as a wet bar, was one suggestion I heard tonight.
yes. And then would we, if proof of that is given to the city before the October 13th end of business deadline, that would then excuse Ms. Stark and myself from your next hearing?
Yes.
All right.
And of any potential fines that I may issue. So I'm not issuing any fines here tonight. I'm giving a second chance to take care of these items.
All right. Thank you.
And based on Ms. Stark's representation that she intends to comply. So I think,
Right.
okay.
All right.
All right. Anything further?
That's it.
Okay, so I'll work on an amendment to the order, get that in writing. Again, tomorrow is going to be really difficult for me, so I'll endeavor to do that by the close of business on Friday. So y'all have it, but you all, I assume, have taken notes and understand what I've said tonight. So nothing further.
No, sir.
Further business. All right, everyone have a good night. We'll adjourn the
Thank you.
meeting. Thank you.